I see we have our correct panel here, and we are ready to begin. Attorney Wise, I believe you represent the appellant in this issue, and if I am correct, would you tell me how much time you would like to reserve for rebuttal?
Yes, thank you, Your Honor. I'd like to reserve 5 minutes.
Okay. I will do my best to let you know when you get around 14, sir.
Thank you.
You may begin.
Thank you. May it please the court. Members of the court, my name is Jervis Wise, and I represent the appellant in this case, Quentin Montgomery. Mr. Montgomery was prosecuted and convicted in the instant case as a principal to a burglary and to several thefts that occurred during the course of this burglary. He was one of about 15 people who were allegedly present when these offenses occurred. He was 18 years old at the time, and he was ultimately sentenced to a little over 65 years in prison. I would like, unless the court would like me to address other issues to start, I would like to begin my argument addressing the sufficiency of the evidence issue that we've raised. And I believe that the briefs that we have filed establish that the state's evidence in this case failed to prove that Mr. Montgomery did, or failed to even allow for an inference that Mr. Montgomery did anything to aid or abet in the commission of these offenses. This court has held, and I try not to cite too much law that's already in the brief, but I think one very important principle in this appeal is that this court has held multiple times that to be a principal to the commission of a crime, one must have a conscious intent that the crime be done, and this is, I believe, the most important factor in this case, must do some act or say some word which was intended to and does incite, cause, encourage, assist, or advise another person to actually commit the crime. The evidence presented at trial may have proven that Mr. Montgomery was present. It may have allowed an inference that he had knowledge that these offenses were going to be committed, but I don't believe that there was any evidence, any competent evidence whatsoever that would allow an inference that he did anything to aid or abet these offenses as required under the principal statute. There was no evidence that he entered either of the buildings. The closest that we have to that is the alleged co-conspirator, Mr. Jackson, who claimed that at one point he made a statement that everybody entered the building. I think from the other evidence we have seen, I think it's pretty clear that what he meant by everyone is everyone who actually did enter the building and commit the offense. Most importantly, on cross-examination, he clarified that he did not see Mr. Montgomery ever enter the building, and he was confronted with the fact that he testified in deposition that Mr. Montgomery specifically did not enter the building. In addition to that, we have no physical evidence suggesting that Mr. Montgomery entered the building or had any part in these offenses. There were latent prints found in the Ford Raptor that entered. There were latent prints taken from a firearm. Mr. Montgomery was excluded. He was excluded from DNA evidence that was found at the scene, or at least he was not matched to any DNA evidence. I believe it's undisputed that he was not driving any of the vehicles. He was not in the vehicle that actually entered the gun store. There's no information on his phone to suggest that he was one of the people who was looking up information on the gun store, who was looking up maps to find out how to get there. Even the ATF agent and the state detective who testified in trial testified they had no evidence linking Mr. Montgomery to the offenses.
Mr. Wise?
Yes, Your Honor.
I want to ask you about two pieces of evidence in particular. One is that right after, or very soon after the robbery at the Tampa gun store, there was a call from Moore's phone to Montgomery's phone. Now, the evidence showed that at the beginning of the evening, Moore and Montgomery both got into the Infiniti. And there was lots of testimony indicating that there was a relationship, a fairly close relationship between Moore and Montgomery. There was testimony that they got into the same car at the beginning of the evening. From the fact that right after the Tampa robbery, Moore's phone, or if we're drawing all the reasonable inferences, Moore called Montgomery after that robbery, isn't there a reasonable inference to be drawn from that Montgomery was no longer in the same car with Moore? So that's the first part the first piece of evidence I want to ask you about. The second one is the day after the robbery. Washington, I believe it was, testified that Montgomery had in his possession a little small .38. And the evidence from the Tampa gun store, the owner testified that one of the firearms stolen was an M380, which is a smaller .38 handgun. From that evidence, couldn't the jury reasonably infer that that firearm had come from the robbery the night before, given all the additional evidence?
Respectfully, Your Honor, I don't believe so. And the reason is because to reach that conclusion, the jury would have to essentially stack some inferences to get there. Number one, they would have to infer that the firearm was stolen. And there was no evidence really to suggest it other than speculation on the part of Washington. He doesn't claim that this was one of the guns. But
he said it was a new looking gun, and it was the day after a similar gun had been stolen by a whole bunch of guys that Montgomery was present with.
He does claim it was a new looking gun, but again, that there are obviously thousands of ways that Mr. Montgomery could have come into possession of that gun. And I believe to jump to the inference that, well, that gun must have been one of the ones stolen the night before would be an impermissible stacking of inferences, which is one of the things that the third district warned against in the GC case, which was a similar essentially principle to a burglary situation as this. So I believe that would take too much of a jump to allow the jury to assume, well, since he's in possession of a gun the day after, that must have been one of the guns that was stolen, even if it looks like a new gun. I think it's far too dangerous of an assumption for a jury to base a conviction as serious as this on such an inference. And again, I would suggest even with that, that still would not prove that Mr. Montgomery did anything that would have aided or abetted in the commission of the actual offense, if that's all we have. Perhaps there's another crime he could have been prosecuted for if that was a stolen gun, but I don't believe that would allow an inference that he actually, again, did something to aid or abet the offense as would be required under the principal statute. Similarly, Your Honor, to the communications that you had mentioned, again, I believe that there was evidence to suggest, certainly evidence to suggest presence at the scene and possibly even knowledge of what was going to happen. But as the numerous cases from the state have held, that's not enough. And I don't believe the communication with Moore would allow any more than a finding of presence and possible knowledge.
It doesn't show that he got out of Moore's car at some point and wound up in a different car?
Well, it does, it could lead to that inference. I agree. But again, I don't believe that shows that he still did anything to aid or abet in the offenses. And I think, I believe it's Mr. Jackson specifically said that Mr. Montgomery was not one of the people who was in the Ford Raptor that actually drove into the building. And I don't believe the state has ever suggested that he was. So the fact that he may have changed cars, I think really doesn't prove anything else about him aiding or abetting. Again, it shows it's additional evidence of presence and possibly evidence that would allow an inference of knowledge, but I don't believe that's enough to allow an inference that he did something to aid or abet in the offense. Again, and I would point to several cases that are cited in the brief again, such as KB, CPP, and GC, which are cases in which similar instances are taking place and the defendant is basically outside looking in, watching. Even in some of those cases, the state's arguing is acting as a lookout. And in all those cases, the courts, being this court, the first DCA and the third DCA, have all said that's not enough. And I would suggest that's exactly what we have here. From as far as the significance of the facts between those cases and this case, I would suggest that they're essentially analogous and really it cannot be distinguished. The next issue that I'd raise in the brief is the failure of the court, I would suggest to consider sentencing Mr. Montgomery as a youthful offender. And I believe that and I don't believe the state disputes the fact that Mr. Montgomery qualified to be sentenced as a youthful offender. The court made a few different comments that suggest that it did not consider or did not believe that it had the authority to sentence Mr. Montgomery as a youthful offender. I think the most telling of the comments the court made was when at sentencing, the state was disputing or rather arguing against Mr. Montgomery's request to be sentenced as a youthful offender. And the court quickly interjected, youthful offender is not applicable. And the choice of the word applicable, I think, is critical because obviously if the court had found that youthful offender was applicable but not appropriate to apply in this case, the court would be exercising its discretion not to impose the sentence. The court didn't choose the word appropriate. It said it's not applicable. It made other comments that we cite in the brief, such as I'm constrained by the law. I wish there was some mechanism that would allow me to sentence young men like yourselves to less than the guidelines or something to that effect. I believe, given the totality of the circumstances, the court, for whatever reason, did not believe that it could sentence Mr. Montgomery as a youthful offender. And I believe there are a couple of possibilities why the court may have made that mistake. One of which is because initially Mr. Montgomery, as charged, was charged with a life felony on the burglary charge. As the prevailing case law holds, you cannot get a youthful offender for a life felony. You can, however, get a youthful offender for a first-degree felony punishable by life. When the jury found Mr. Montgomery not to have been armed or not to have armed himself during the alleged burglary, that transformed the life felony to a first-degree felony punishable by life, which could have been a conviction where he could have been sentenced as a youthful offender. The court may have been mistaken on that, either on the fact that the conviction was for a first-degree PBL as opposed to a life felony, or it may have been mistaken on its classification of a life felony versus first-degree PBL.
Isn't there an objection about that? I'm vaguely recalling something, correctly if I'm wrong, at trial, because I think one of the defense attorneys kept saying, well, you're facing a life felony and there was, or you're going to be in jail for life. And so there was some objection made at trial highlighting that this is not a life felony and the defense counsel should stop insinuating that to the jury.
Your Honor, I when you first brought that up, I didn't recall that, but with the last statement, I believe so, and I apologize. I had focused more on what occurred at sentencing with regards to this issue. I believe there was a comment to that effect. I'm sorry.
I mean, just in general, don't we have to assume that the sentencing judge knows what the law, the applicable law is? We have to start with that presumption, and then doesn't that sort of reinforce that the court probably pretty clearly knew what the applicable penalty is?
I believe so. And again, in either situation, the potential statutory maximum was life, but the classification and where I have seen trial courts make this mistake, because it is a I'd say kind of a unusual distinction, but either way, the statutory maximum was life, but under Florida law, it was charged initially as a life felony as opposed to a first-degree PBL. And with the life felony, the YO could not apply. With the first-degree PBL, it could. And I think that's the difficult distinction, because both charges carry a potential life sentence, but under Florida law, the classification is critical, especially when we're talking about whether the youthful offender can apply. So I do think we obviously would want to presume that the court knew the law, and I think the court, this is a very experienced judge who has been on the bench for many years, and I'm certain that she did know the law very well. But I believe she made a mistake in finding that the youthful offender was not applicable here. Another potential that I think could have factored into that is that just a month before Mr. Montgomery's sentencing, the youthful offender statute was changed. For many years, I believe since its inception, up until about 2008, I believe, it allowed for the youthful offender to be applied if the defendant is less than 21 years old at the time of sentencing. That changed, I believe, for about a decade when the statute was amended to say, it used to apply when the defendant was less than 21 at the time of the offense. It changed for about a decade, I believe, to the youthful offender can only be applied if the defendant is less than 21 at the time of sentencing. A month before Mr. Montgomery's sentencing, the statute went back to its original form in that regard and allowed for the youthful offender to be applied when the defendant is less than 21 at the time of the offense, regardless of how old he is at the time of sentencing. Mr. Montgomery, I believe, happened to be 21 years old at the time of sentencing. Perhaps the court was mistaken in the change in the statute that had recently occurred, or potentially believed that the change was not retroactive, and I believe that it was. But for whatever reason, the court, I believe, felt that the youthful offender could not be applied in this case, and the law, I believe, specifically allowed it to be applied.
I need to let you know you're at 15.
Oh, thank you, Your Honor. In that instance, I will take my seat until rebuttal.
Thank you.
May it please the court, David Campbell representing the state of Florida. To begin with the issue one, the sufficiency of the evidence, I'd first like to point out that many of the cases that were cited by appellant happened before Bush came out when we did the change of the standard of review. A lot of those cases we're talking about the special standard, and right now we're simply under the competent substantial evidence standard. So we're not doing anything special. It's just simply whether or not the state presented competent substantial evidence that the fact finder could find guilt beyond a reasonable doubt. And what happened that day that the jury heard, they heard evidence that at the beginning this was a group that was more the ringleader. There was evidence that he was the ringleader. He was gathering a lot of people together. I believe it was Mr. Washington that actually testified that Moore had spoken to him about knocking off hitting a gun shop. There was testimony that Washington, I believe, was the one who called Brady. Brady then shortly shows up with Mr. Montgomery in tow. So you have a lot of evidence of this group getting together. There's 5 stolen vehicles, as Mr. Washington testified as to why they'd have stolen vehicles, so they couldn't be, traced back to them. It's, as far as Mr. Montgomery's knowledge of what was going on, it'd really be kind of difficult to believe he couldn't know, as they're getting together, all these people. They get into the stolen vehicles, and they then caravan first to the 7-Eleven. We know that Mr. Montgomery is in the lead vehicle with Moore. They go into the 7-Eleven. Washington, I believe, points out Mr. Montgomery on the video as being there. And I believe Mr. Montgomery was wearing shorts with a hoodie that was up tight over his face. So we have Mr. Washington testifies even that he steals a pair of gloves, so he's not going to leave fingerprints. Once again, this is a group of people all heading out in the late at night in stolen vehicles. The chances that Mr. Montgomery doesn't know what's going on are almost slim to none. They then head to the Osceola store. Even if Mr. Montgomery didn't know what was happening before that, he certainly does when the Raptor shows up. They've all congregated behind with their vehicles. The Raptor shows up, smashes through the wall. Actually, I believe it went around to the front because there's a problem with a pole being in the way. And then several of them race inside, realize that it is a scooter store instead of a gun store. At this point, he certainly knows what's going on. They're smashing through, buildings trying to get guns. I believe one of them actually said, no, that's not a gun store. So that's even being said out loud. And they all regroup, get into their vehicles. There's testimony they all get in, and that all of them get together. So there's no talk about Mr. Montgomery not being there. They all then, Mr. Montgomery is in the vehicle with Moore, who's searching for gun stores. So once again, he's going to know what's going on.
Mr. Campbell, are we
Yes.
sure of that from the evidence? Because I thought there was evidence that soon after they left the 7-Eleven, there was a call from Moore to Montgomery. Am I not remembering that correctly? Because wouldn't that suggest that at least at that point they were no longer in the same car too?
The testimony from Mr. Washington after the Osceola robbery is that they all got back into their vehicles. Yes, as to exactly
But
which vehicle.
he didn't say specifically which vehicle. And we've
Right,
got the phone records that suggest that maybe it wasn't the same vehicle.
That is true. We have, when they're driving down and you have the several calls from Moore to Montgomery's phone, and they're pinging from the same towers. In fact, when they get into Tampa, I believe they're both pinging off the Pinellas County tower. Whether or not that's an accidental dial like you do with the modern phones, or he was actually calling Mr. Montgomery in another, who was in another car. The evidence does show that Mr. Montgomery was still in the caravan in the same vehicle. Yes, it's not for sure that they got into the same vehicle when they were after the Tampa store and left, when there were still calls back and forth. But for whatever reason, the phones were together in the same geographical area, and there were calls going back and forth. The important part is that the towers and the calls and the testimony put Mr. Montgomery back into the caravan after it left Osceola and came down to Tampa. When they get to Tampa, they then the vehicles all once again group up, and they wait till the Raptor gets there. Mr. Jackson at this point then testifies that after the Raptor smashed through the wall, the cars are empty and that everyone went inside. Any conflicting testimony that Mr. Jackson gave would be just that. That would be an issue for the trier of fact. But he did testify that all the cars were empty and everyone went inside. And they also testified that everyone who went inside had their faces covered. We didn't see the video, at least as part of the record, but we did hear what it showed. And it showed everyone inside wearing a mask, and they were all running around snatching, grabbing weapons. So that right there, his covering of his face, his racing inside the building after the Raptor just smashed through it, that's intent. That's providing assistance. He's actually an active participant in this case. So that evidence right there, that he would have had knowledge, the jury could have determined that from Moore and his conversation, being at the previous botched attempt, all the way down to Tampa where the Raptor crashes in again, evidence that everyone goes in, so everyone would have included Mr. Montgomery, and that he had his face covered. From that, the jury can find that he intended was an active participant, and he was a principal in this crime. There's also afterwards, the next morning, the evidence that he was seen with a small 38 revolver, which matched the description of one of the items taken. And he was also speaking to, the jury didn't hear that he was a fence, but the jury heard that Billy, I believe his name was somebody that Washington had sold before clothing, and I think car parts. I don't remember exactly what it was. So once again, that's circumstantial evidence that he was at the gun store and he did have a weapon from that recent robbery. Let's see, as far as the sentence, were there any other questions as far as his knowledge, his participation, or being a principal? All right, with that, moving on to sentencing, I have a question about.
Oh, go ahead. If you want to do some, go ahead.
Oh no, I was just going to do sentencing, but no, I'd rather finish off the.
No, I did not have a question about the previous matters you've discussed. I have a question about the admissibility of evidence, but go ahead with sentencing.
Okay, as far as, I don't believe the evidence shows that the court felt that they could not give a youthful offender a sentence. The comment about being constrained by the law, that was said in relation to a downward departure where there are, certain rules. There were a couple reasons that the defense argued for a downward departure. They even had a motion about this, which explained a lot of the law and their reasoning. So I think even if the judge was perhaps mistaken, I think after they just seen a defense motion explaining the law, again, that just goes to the idea that the court wasn't mistaken as to whether or not they could give this juvenile sentence. I would say that even with the defense attorney who said, I can understand that 5 years is not appropriate in this situation. I mentioned that the state even begins arguing the youthful offender again. So it doesn't appear that anybody believed at the hearing that the judge felt they couldn't give that he wasn't eligible. They just felt it was not appropriate. I mean, these were 36 first-degree felonies. He was scoring 65 years. So as even the defense attorney said, that's probably not appropriate. The judge later said, if you'd given me anything, I would have, not given that low as far as youthful offender, but I would have given some mercy. But the constraint by the law was to the several reasons to give a downward departure, which appellant did not qualify for. Therefore, when he did not qualify for it, the judge was constrained. She couldn't just, well, I'd like to give it to you, but I can't. He wasn't a minor participant. He was a principal in this. It wasn't an unsophisticated crime. They stole vehicles to hide their identity. They were organized. They got into a caravan. They headed to two places after one failed attempt. They reorganized, regrouped, went down to the second robbery, which they found using their cell phones, once again They even were savvy enough to make sure they went out of county because they were known by Orlando PD. So they then organized, they used the car as an instrumentality to break in. After they snatched and grabbed, they then all once again got back in their vehicles and left. They apparently had the weapons sold pretty quickly the next morning. So this was just not what you would consider unsophisticated.
Could I interject about the admission of the evidence of the stolen vehicles? Could you sort out the basis of the trial court's decision to admit it, your tipsy coachman argument on appeal, and
yes.
Are you abandoning the trial court's? What it sounds like, at least the way you characterize in the brief, is that the trial court ruled that it was Williams rule evidence admitted for identity and preparation, not that it was relevant evidence based on its being inextricably intertwined. Are you making an argument that it's inexplicably? You did not. You said it is similar fact evidence, and it has to do with preparation.
I didn't mean to abandon any of the reasons that the judge gave. No, I was just adding to it. I believe the judge didn't specifically say like preparation or showing intent. I was wanting to just add to it. I believe that the evidence of the stolen vehicles definitely goes to show their plan, their intent, their preparation. It pretty much goes to show everything. I believe it is admissible Williams rule evidence. So no, I was just meaning to add to what the court had said. If it came out that I was trying to abandon the judge's reasoning, no, that wasn't my
okay.
intent.
So you were adding this tipsy coachman argument for a different purpose, which is plan, knowledge, preparation, absence of mistake. But so I have two just a little bit misgivings. One, I mean, it inextricably. I mean, I think that the defense counsel argued against an inextricably intertwined rationale. But my understanding is the trial court admitted it under 90.404, and you are arguing under 90.404. But even under 90.404, isn't there a balancing test? Let's say that it's plausibly evidence of preparation and plan, but do we balance the need for that? I mean, what did that add to the state's case that overrides the harm to someone whose defense was, I might have been in and around there, but I didn't participate. The harm to that defense by saying, oh, well, you probably stole the vehicles. That's what they're going to say. Talk to me about that balancing test.
Well, Your Honor, if you're almost like arguing like a harmless error or something, no. Well, balancing, since I think it is directly admissible to show preparation, they were talking about the stolen vehicles beforehand. So once again, I think it does go directly to his knowledge. Whether or not could you prove the charges without knowledge of the stolen vehicles? I definitely believe you could. You have I believe Mr. Jackson's testimony and all of the cell phone evidence, and Mr. Washington put him right there and then put him inside. But it goes directly to preparation. I think it goes to the state is directly arguing against his argument that, oh, I was just there. No, you were just there in the stolen vehicles. That shows you knew what was going on. No, you just rode through. He just followed them to one break-in in Osceola, then followed them to another one in Tampa in stolen vehicles. You knew full well what was going on. This is not.
There's no evidence that he knew that the vehicles were stolen, right?
There is no. Once again,
that said, I don't understand why that evidence wouldn't be necessary to complete the picture of the offense for the jury.
I don't think that it should be excluded. You can make an intertwined, but it's relevant evidence, and I don't see how it can be. You're saying because it'd be prejudicial, it may be, but it definitely goes to show his preparation. I mean, I think it's allowed just by what the statute says, why it's allowed.
I think what Judge Atkinson is asking, and forgive me if I misunderstand, but how does it show his preparation? He's got no knowledge. So as to him, wouldn't it be unfairly prejudicial?
Well, I think the state needs that to counter his claim of lack of knowledge.
How does it counter his lack of knowledge if there's no proof that he had knowledge, that he participated in the theft of the vehicles, or that he knew they were stolen?
Could you say that one more time, please?
Yeah, you said that it's admissible to prove his knowledge, but how does it prove his knowledge? His knowledge of what? His knowledge that they're burglarizing a gun store. You'd have to have evidence that he knew the vehicle was stolen for it to be relevant at all to his knowledge that they are robbing a gun store, or that he's preparing to rob a gun store, or that he intended to rob a gun store, or they had the plan to rob a gun store. Without evidence of his knowledge of the stolen nature of the vehicles, why is it relevant to prove any of those things? Just the fact that they were stolen, which does, they're going to say, which does prejudicially place in the jury's mind the possibility that he stole them.
I can see that. Okay. I would say, well, for
I guess my point is this.
Oh,
go ahead. Sorry, go ahead.
Oh, no, I mean, well, maybe I didn't use the words, but I think if you're going to, you need some evidence to prove that he did know about it, and that would
know about what?
That would tend to go. It'd be, I mean, if you do balance it, you need something to use to prove that. So
to prove what?
Based on that,
about what? To prove that he knew about what?
That he knew that they were from the get-go, from the very beginning, going to rob a gun store. That shows that he had the intent that it happened, which is necessary as a principle. So
intent, knowledge, intent to rob a gun store, or not rob, burglarize and steal guns. Intent, knowledge that was the plan. That was all. It was necessary. It was relevant under 90.404 to introduce the fact that these vehicles were stolen to prove that Montgomery had a plan to burglarize the store, had knowledge that was the collective plan.
Well, I think he was
prepared. But I'm saying, how is that relevant to any of those permissible purposes under 90.404 if there is not evidence adduced that indicates that he knew the vehicles were stolen? And is that necessary?
Okay, I'm trying to think back. I know Washington was testifying about the stolen vehicles, and he knew that they were stolen. So yes, there is nothing in there that specifically says that Montgomery knew the vehicles were stolen, but I would say this is part of the plan, and it was a judgment call on the part of the judge that it was.
So are you saying there's evidence that from which the jury could infer that Montgomery knew they were stolen because there were discussions, there was testimony about discussions to which he might have been privy that would have suggested to the jury that he knew they were stolen?
I would say that would be reasonable. Yes, he was with Montgomery. He was with the ringleader. He was called over by Washington, I believe, when Moore had talked about knocking off a gun store. So I don't see how you can say it's overly prejudicial when it does go to his knowledge and intent. I know you've got this fine line here about, well, if he didn't know what he perhaps learned along the way, but the jury can infer from the evidence that they were discussing going to a crime that he knew from the beginning.
Let me ask it in a different manner.
Yes.
Assuming that the jurors needed to know that the whole ringleader and everybody had planned to use vehicles that could not be traced back to them, did anybody ask for a limiting instruction to the jurors that the vehicle may have been stolen, but at this point there's no evidence to suggest he in fact knew of it? That's direct. There are certain limiting instructions that mine may not have been artfully put together, but did anybody ask for limiting instruction to the jury at all about the nature or quality of this evidence?
I don't remember that, Your Honor. No, I don't remember a limiting instruction on this. I'd have to go back and review.
That's okay. I just wondered. I'm sure if there was one, somebody would have briefed it.
There was a lot to this case, so a lot of pages. No, I didn't see that. if this court does feel that that is somehow was improperly admitted, I would certainly argue that considering the other evidence that is not related to the vehicle, the key testimony of Jackson, putting him in the Tampa gun store. So even if there was no talk about the vehicles being taken, he's still in those vehicles through the 7-Eleven, the Caravan to the Osceola store, then down to the Tampa store. And then he's put inside the building by Jackson saying the cars are empty, everyone went in. So the conviction could certainly have been achieved without having this in there if the court feels that it was improperly admitted. We have him inside the store covering his face. That shows intent, that shows participation. So if this is proper, and if the court does feel that was the balancing, the judge abused his discretion, I would say that's merely harmless error because of because the other evidence, circumstantial, yes, but we're still on now that's what we are, substantial competent evidence. He was there the whole stretch of the way. He went in, despite what vehicle he may have been in, whether he changed vehicles or not. Cell phone evidence does show that he was there the whole way.
I need to advise you that you're at 20 minutes, but I will award you 30 seconds to sum up.
I would just say that, Your Honor, there's competent substantial evidence to show that he was a participant in this, that he was more than just a bystander standing outside and watching this happen. Jackson puts him racing into the store because everybody went in. So we'd ask that you would affirm because there was substantial competent evidence from the jury could find every element proven. Thank you very much.
Thank you, counsel. We are ready for rebuttal now, counsel.
Thank you, Your Honor. I didn't quite get to to issue 4 of the brief, which was the Williams rule evidence that came in, but I will address that because it came up during the state's argument quite a bit. I think one important factor that was not mentioned during the state's argument is that when the state proposed to present this evidence, it told the trial court that it was not intending to present evidence that the vehicles were actually stolen. It had told the court that it was intending to introduce evidence from the true owners of the 5 vehicles and that the defendants were not known to them and they never had permission to use their vehicles, which I think is calling a rose by another name. Clearly, this was evidence that was presented of these 5 vehicles being stolen. And perhaps the state's comment during the pretrial hearing that it wasn't actually going to present evidence that the vehicles were stolen somehow minimized the potential prejudicial value to the trial court, at least in the trial court's assessment, because I think that the balancing test that's required under 404 is critical here. I don't believe there's any probative value to that evidence. It's not evidence that would have been inextricably intertwined because it was not evidence that was necessary to complete the story of the case, whether the vehicles are stolen.
Mr. Wise,
Yes.
let me stop you right there on that, because there was evidence that the state presented, not objected to, showing the cars going by and the SunPass capturing pictures of their license plate. So I know if I were a juror, my first question would be, well, did you go knocking on the doors of the people who own those cars? Who do those cars belong to? Why are you looking at these people? And so the state would have to say, well, if we go to these people who actually own their cars, you know, this is who these people are. Why aren't we indicting them? Well, it's because their cars were stolen very recently before all of this happened. So looking at it that way, how is this not necessary to complete the picture of the jury? Because in theory, we could have 5 completely different people, you know, being charged with these offenses.
Absolutely. And I believe the reason it's not important is because the owner of the car is not in any way relevant to the commission of the burglary and the grand theft.
Except to explain to the jury why the owner of the car is not the person on trial.
Yes, and if any of the defendants had opened the door to that and argued, well, why don't we have the true owners of the car here? I think that would have changed things, but I don't think that it was necessary for the jury to speculate as to who the owners may have been. And for all they know, it may have, you know, the defendants could have been the owners of these vehicles. And unless the defense made that an issue, I don't think that it opened the door to the relevance of who the true owners were.
Well, if you were a juror and you had evidence with these license plates, wouldn't that question come up in your mind? Well, did they run the tags
I
to see
don't,
who is going along? To corroborate the statements that they all trekked from Osceola County to Tampa to commit this robbery?
I don't believe that it would, but I think that I would assume that they must have, unless someone questioned it, I think I would assume that they must be the true owners of the vehicle. Unless someone suggested that they weren't, I think I would assume they must have been. And unless the defense opened that door, which they didn't do, I don't believe that evidence had the relevance. But even obviously assuming for purposes of argument that it did have some probative value in that regard, I would suggest that presidential effect far outweighed whatever the probative value would have been. We're hearing evidence of 5 vehicles being stolen, and contrary to what the state said it was going to do in the pretrial hearing, we're hearing we're hearing in detail how these vehicles were stolen. And there's no evidence whatsoever linking Mr. Montgomery to any of those vehicle thefts.
Well, and
And
that being the case, doesn't that sort of cut against your argument of unfair prejudice? I mean, if there's nothing that ties him to the robberies, he doesn't have to know that the cars were stolen.
True, but we have nothing tying anyone to the robbery. So the jury is left to speculate, well, he must have stolen these cars, even though he's not charged with it. And
Wasn't driving any of them.
It wasn't driving any of them, correct.
And
So I
wasn't
think
found with
that-
any of the keys or anything on him like Mr. Moore was, for example, right?
That's correct. That's correct. But again, when the jury hears that we have 5 stolen vehicles that are used in this crime, they're left to speculate that Mr. Montgomery must have been part of that. But in the end, and going back to the sufficiency issue, there was no evidence really to show anything other than presence and possible knowledge at the time of the burglary, not at the time of the car thefts.
We should let you know that your time has expired, but if you would like 20 seconds or so to summarize, please go ahead.
Thank you. And I would just like to briefly summarize. One of the comments the state made was that it's difficult to believe Mr. Montgomery couldn't have known. And that may be. I would dispute that, but I think that doesn't matter. Because again, what's important for the sufficiency is doing something to aid or abet, not presence and knowledge. And I believe that's all that was proven. Thank you.
Thank you, counsel. Thank you both. Appreciate your presentation on behalf